So very good evening all the participants to this last attempt batch for the old syllabus. Although IBPI has removed the new notification from their website, I don't know for the reasons best known to them. Maybe they want to defer it a bit further. But for practical purposes, I think the time available with us will be up to 15th of September only. Because last week they normally preserve for the last entrance. Suppose somebody's payment failed and all those things. So normally slots are not available after 20th of September. So you have to plan it accordingly. Try to appear by 15th of by say by end of this August if possible, or in the first week of September only. I am with you. I will exert myself fully. I am always available. I don't do much work. So I am normally available for everybody who seeks my help. Today's session will be on Digital Personal Data Protection Act, DPDP Act and rules. It's a new law. So normally they will be asking you one or two questions out of this act. So today's session will be taken by Sudhakar Vardhanapuji. Sudhakar Vardhanapuji, now it's all yours. Yes, please.
Right. Thank you, sir. Today we have the session on Digital Personal Data Protection 2023 and Rules 2025. Sir, I'm audible, sir?
Yes, very much audible.
Yeah. So, what we need to understand is why did this come into being? So, basically, from 2000, 2005, 10 onwards, the social media has grown very large. And therefore, there were a lot of problems coming up. And already Europe had this general data protection rules. And we took leaf from that, and Government of India came out with a Digital Data Protection Act in 2023. And to operationalize it, the Government of India has published the DPDP rules from 13th November 2025. And amongst the rules, Rule 1, 2, and 17 to 21 will come into effect as on the date of publication, which is 13th November 2025. And the rest, some come into effect from after 1 year after date of publication, and a few and some come into effect from 18 months from the date of publication. Right. So this is a very important topic. Sir, let's go to the next. Yeah. So, for example, everybody, we order food, we order so many things from the internet. So there are a lot of Aadhaar-based services, and then a lot of streaming services like Netflix, Prime Video, and other things. So where the personal data is required to avail of those services. So therefore, in here, we have Indian, as far as Indian users are concerned, we use those platforms which are from India, and certain platforms which are from the foreign countries only. So here, what we, we have understood is because of the huge growth of digital social media and digital services, there is a lot of fraud happening. There are a lot of data leaks, and as you very well know, lot of companies, they sell the personal data also. We are told, it is alleged that they sell the personal data also, and it may be misused. So, and of late, because of the advent of AI, deepfakes, and unauthorized profiling, and also the voice also is being cloned, and which results in digital harm. And because earlier, there were no policies to contain the challenges that arise because of the digital harm, and therefore, taking all that into account, the government of India has decided to come out with a new framework, and also, and the penalties are very steep, starting from 50 crores, 200 and 250 crores. Sir.
Just
Yeah. So this all started from the Puttaswamy judgment, which is very, very important, which stated that Supreme Court held that the right to privacy is a fundamental right under Article 21, and therefore it has directed the government to come out with a new data protection law, or rather amend and reorganize, something like that. And from 2023, the act was passed. The Digital Personal Data Protection Act was passed. And from 2025, the DPDP rules were gazetted so as to operationalize the act's implementation. And now, what are the objectives of the DPDP Act and Rules Framework? So, one is there is a legal clarity on how the digital personal data is used. Then there is data which is processed in a fair, lawful, and transparent manner. In the sense that the person who is giving the data, who is known as the data principal, like in the Puttaswamy judgment, where they have said that the right to privacy is a fundamental right under as per Article 21 of the Constitution here. So this Article 21 shows the transparency, and it is also the for the data principal or the individuals.
yes, please, Sudhakar ji. Sudhakar ji, you are not audible. Sudhakar ji, are you there?
He is not audible, sir.
Okay, okay. So, KV Kumar ji, you can take up, please, if you want. Yes, please. Till the time
Yes,
Sudhakar ji comes.
I cannot go through this slides, sir. But 5 minutes I can explain the DPDP Act, sir.
Okay, okay. Please explain.
I cannot
Please
go
explain.
through these
Please
slides, sir.
explain. In the meantime, you will join. When you will join, we'll start. Oh, please.
Okay, sir.
Yes, sir.
Yes, Sudhakar ji, please. Please.
Yes,
continue.
sir. Recording फिर करना sir. Recording हो रहा है इसमें?
Recording is on already. Yes.
Okay, okay. So it is also understood that there may be a data breach and data leakages for which the penalties are stiff, amounting from 50 crores to 250 crores. And then it is also important that all these platforms, the digital platforms, build trust in this age of AI, cloud, and digital public infrastructure. Yeah. So what is the scope of the Act? So what it covers and what it does not cover. So this data is which it covers digital personal data collected from within India, and offline data which is collected and later digitized is also will also be covered, and processing of personal data in India is also covered, because there is a data processor, there is a data fiduciary, there is a data principal, and there is a data processor. So that processor who processes the personal data in India also is covered. And then companies, regardless of origin, offering goods or services to users in India, like in the sense that, for example, certain platforms like certain platforms may not have an Indian server the servers may be abroad, but users may be from India. Such platforms are also covered. And what is not covered is, so the purely offline data, which is never digitized, is not covered. And data used solely for personal purposes is not covered. For example, saving a contact number, somebody's contact number or one's phone is not covered. And that which pertains to national security, law enforcement, and other government notified exemptions, and which are subject to safeguards, are not covered. So now let us look at the key definitions. Like we were referring to data principal, data fiduciary, and data processor. So data principal is the individual whose data is processed, and those are the adults and who can take decisions for themselves. But for children or persons with disabilities who are not able to take decision for themselves, the legal guardian will act as the data principal. Now, what is a data fiduciary? The entity, which is the company, app, or website, that determines the purpose and means of processing personal data, is the data fiduciary. For example, Meta is there, Alphabet, Google is there. They are all data fiduciaries. And data processor, a third party engaged by the data fiduciary to process data on its behalf, that is the cloud provider or somebody, or the data processor. And there is somebody called the consent manager, enables users to give, manage, and withdraw consent transparently. It must be an Indian company because there will be accountability. And there is a data protection board, which is an oversight board, which oversees the implementation, hears the complaints as per law, and exercises the powers of a civil court. And any challenges with whatever has been, which goes through the data protection board, we will go on appeal to the TDSAT, which is the Telecom Dispute Settlement and Appellate Tribunal.
So participants, this slide is the most important slide, and they can ask you questions in two ways. They can give you example. Suppose they will give you an example, Facebook. So whether Facebook is a data principal, data fiduciary, data processor, and things like that. They might give you example of Meta and so many other things. So they will give you examples, and they would like you to identify under which definition it fits, whether it's a data principal, data fiduciary. So I would request all the participants to please post in the group the various parties which are involved under this DPDP and how to identify them. And they, in the past also, they've asked questions on data principal, data fiduciary. Yes, please. Next.
Yes, sir. And then there are 7 core privacy principles. They are consent and transparency. So there's the consent and transparency. It must be free, specific, informed, conditional, clear consent, and plain language notices. Here, the most important point is plain language notices. It should not be couched in legalese or language which the data principal cannot understand. Then there is a purpose limitation. So the data collected for one purpose cannot be used for unrelated purposes. Like, for example, when a certificate is given by an institution, it says it is given for the purpose of so and so, so and so. Like that, here, the data which is collected for one purpose can be used for only such purpose and not for unrelated purposes. Then the data minimization, only data necessary for the stated purpose may be collected. No extra data may be collected. Even if collected, they cannot be used. And then what is much more important is reasonable steps must be taken to keep the data accurate and up to date. Which here, the data principle where, suppose, for example, a data has been entered wrong or there are mistakes. So they have the right to make the corrections. Here, that data accuracy also helps. Then the storage limitation, it is retained only as long as necessary and then deleted. Then there are security safeguards such as encryption, audits, secure design. The architecture must be secure. Then the breach must be prevented. Then for the accountability, the fiduciaries answer for compliance, including their processors' actions. Then, in order to ensure if there are any challenges, if there are any problems for the data principles, they can approach the Data Protection Board, which is a fully digital online adjudicatory body. And this Data Protection Board is a digital office. So it investigates breaches and privacy violations. It can summon documents and conduct hearings because we already said it is in the nature of a civil court. And then it can order audit and issue binding guidelines. And it can impose penalties for non-compliance and breaches and ensure uniform application across sectors, technology, health, fintech, and government service, to name a few. Here, if the orders of the Data Protection Board are not satisfactory to the data principle, they can appeal to the Telecom Dispute Settlement and Appellate Tribunal. Then the penalties, like we said, they are very steep, starting from 250 crores, which is if there is the security data breach leading to security safeguards, which is like if there is a architecture problem, then it will the penalty is to the tune of about 250 crores. And if a failure to notify, so it says that if there is a data breach, it should be immediately brought to the notice of the Data Protection Board. If it is not notified immediately or non-compliance involving children's data, then it is, the fine is, the penalty is the tune of 200 crores. And other than these two, any contravention of the rules, the penalty is 50 crores. Then, what are the key features of 2025 rules? Here, organizations get 18 months to achieve compliance. And standalone consent notices, they must be in clear, simple language notices, cannot be buried in T&Cs, must explain use and withdrawal of consent. Breach immediate plain language notice to affected users and the board on any breach delay attracts 200 crore penalty. So if there is a breach, they must immediately inform the Data Protection Board and what action they are proposing to take. Then the grievance officer, fiduciaries must publish DPO grievance officer contracts and maintain proper records. And there is somebody called the significant fiduciaries. They are large or high risk processors, face data protection IAS, DPIAs, stricter monitoring and possible local storage requirements. Then the board is a digital first board, online complaints through mobile app, digital evidence, AI enabled case tracking, and through standardized forms. So what are the rights of the data principals? Their right to access their personal data. They have the right to correct or update inaccurate data. They have right to erase data no longer necessary. Right to nominate a representative. That is the anybody who are ill, who are not able to make the changes in any manner, they can nominate a representative. The maximum time to respond to a data principal request is 90 days. So in case of children or persons with disabilities, consent and these rights are exercised through the legal guardian who acts as the data principal. So alignment with the RTI Act. This is very important thing, which balancing transparency and privacy. Here, earlier, before this, the RTI Act was implemented, which brings about transparency. But whereas here, the importance is given to privacy due to Article 21 of the Constitution of India. So the framework amends Section 8(1)(j) of the RTI, wherein personal information is no longer automatically barred from disclosure. It must be carefully evaluated. And disclosure continues where public interest clearly outweighs privacy harm. There are investigations into corruption, misuse of public office, large-scale public welfare issues, environmental and public health hazards. The amendment removes ambiguity for public information officers while preserving both democratic values. What is the overall impact for individuals, industry, and governance? For the individuals, there is greater control over their personal data, and they have clear and enforceable rights. They have easier consent management. It is a time-bound redressal, which is 90 days. So, for the industry, it is a clear legal framework and higher compliance standards for large players and anyone for that matter. Enhanced digital trust and global compatibility, encourages responsible AI, IoT, and cloud innovation. For the governance, it harmonizes privacy and transparency and follows strong privacy norms. Modern digital first regulatory ecosystem supports the Digital India mission. So it is basically a modern, balanced, and citizen-first framework. The DPDP Act and roots balance innovation, privacy, transparency, and legitimate state functions, establishing strong rights and strict penalties, and positioning India as a responsible player in the digital economy.
So what we will do,
So,
and what is important? First of all, we have to remember certain definitions like data principal, data fiduciary, data processor, on which questions are asked. Second most favorite topic of the examiners is regarding the penalties. So we'll be sharing with you a penalty chart also. And now let us have a look at a case study also on this, which I have already shared in the group. Just in the meantime, I'll request KV Kumarji to
Yes,
please guide us regarding this
Yes, sir.
DPDP Act. Yes, please.
Yes, sir. This good evening, Gupta sir.
Good evening.
good
I
evening, sir.
am KB Kumar from Hyderabad, insolvency professional, sir. This
Yes,
the just 5 minutes with respect to exam point. Only
Yes.
I will explain you, sir.
Yes, yes.
Nothing other than that. The
Yes.
DPDP Act reading and going through that takes a lot of time.
Right.
But what is relevant to our examination? What is the genesis of this DPDP Act?
Hmm.
I have not gone through when these slides, but
Okay.
in my view, I will explain you within 5 minutes what is
Yes.
the gist of this act and what are the questions that are framing in the examination point of view.
Hmm.
That only I will discuss, sir.
Yes, yes.
This DPDP Act came into existence on 11th August 2023. What is the genesis for this? Justice K.S. Puttuswamy, retired High Court Judge of Karnataka, he has challenged the privacy of data. That's why this act is called digital personal data, not any data, nation data, private data. It is nothing concerned with data, personal data. Thereby the definition of data principle. Data principle is an individual who submits the data to the data fiduciary. So this case Puttuswamy judgment, this Supreme Court in 2017 clarified that data of a personal should have a privacy. So it is a 9-bench judgment. The judges 9-bench judgment, they directed the government to frame the act for digitalization for the private data. In this act, there are 5 definitions which are very, very important. Other than that, nothing will be asked in the examination, sir.
Yes.
As Gupta sir told.
Yes.
If
Only
you go
two
to
things, basically either definitions or penalty.
definitions and penalties.
Right.
And appeal also.
Right.
And under which ministry it is covering? Ministry of Electronics and Communication. It is monitored by. and the order of the board is challenged within 60 days to the tribunal, appellate tribunal. That is not
Right.
mentioned in the act, sir. That is mentioned in the appellate tribunals that act, that within
Great.
60 days we have to appeal.
Great.
So the 5 definitions that I am going to give you, sir, this is data principle. Who is a data principle, sir? If I am submitting the data to the consent manager, he is called consent manager. And that consent manager will give it to the data fiduciary for processing. Who will process the data? He is called data protection officer and data processor. This is 4 definitions are there. Data
Right.
principle, data fiduciary. Fiduciary means very big person, sir. It is a company. Data principle is an individual who submits the data. That consent manager, who is the contact person between fiduciary and the individual, he is the consent manager. This data principle, he can withdraw also his consent. And third thing, data protection officer, who is appointed by the data fiduciary, and another person is data processor. These definitions are interlinked, and it should be mandatorily read who is data fiduciary.
Right.
This definition or nomenclature may be big, but the definition is very simple. Who process the data? Who process the data? It is generally a company. And coming to the penalties, there are 6 penalties, sir. From
Right.
250 to 10,000, not 50 crores, 250 to 10,000. If any data, if anything is violated by the data principle, the penalty is 10,000 only, sir. The maximum penalty is 250 crore. If it is violated by the data fiduciary, the penalty is 250 crores. If any data required by the board and breach of board's directions, it is 200 crores. If it is with respect to child, it is also 200 crores. These 3 definitions, 3 penalties are more important. Third penalty is 10,000. 10,000 means, if being a data principle, if I do not follow the procedure given by this data, then I will be penalized by 10,000 rupees. If you violate any
Right.
act or rules of this DPDP Act, then penalty is 50 crore. These 5 definitions and 5 to 6 penalties will survive you the questions in the examination.
Right.
If you go to that, if you go deep into that, you cannot understand the entire act.
Right.
Your time is very limited.
I hope now participants can see this penalty chart also, which is given in
Yes,
the schedule.
Penalty chart I will explain in 2 minutes, sir.
Right.
Penalty chart, I am having this penalty chart.
Right. So I
There
hope
are
it is
7.
it is visible on screen also. Is it visible?
I am having this act, this scheduled of
No,
penalty.
Kumarji, I am asking the other participants
Okay,
whether
sir.
Yes, sir. It is visible, sir. It is visible,
okay.
sir.
Okay.
The schedule is under
But
section
the
33. Yes, sir.
Right.
schedule there are 7 points in the schedule, sir. 1, breach in observing the obligation of the data fiduciary. You remember data fiduciary, sir. Any breach by data fiduciary, it is 250 crores. Breach in observing the obligation to give the board or affected data principle notice of a personal data breach under subsection 6 of section 8, it is 200 crores. Only they will ask penalties, sir, in the examination, nothing else.
Right.
If you take any examiner, if you ask anybody who is appearing for the exam, they will ask penalties or definitions, or
Right.
who is the controlling ministry and who is the appellate authority, in how many days we have to apply. These are the 10 to 15 questions they will ask repeatedly. I am telling you, sir.
Right.
And third question is breach in observance of additional obligations in relation to children. Children data में कुछ गड़बड़ किया है, that is 200 crores penalty. Fourth one is very important. Fourth one is breach in observance of additional obligations by significant data fiduciary. Who is significant data fiduciary? For each clause, they will appoint significant data fiduciary. Who will appoint this data fiduciary? Will appoint significant data. If more number of data is available in one sector, they will appoint significant data fiduciary. That significant data fiduciary violates anything, the penalty is 150 crore. The fifth penalty is if any breach by data principal, that is fifth definition, that is 10,000, sir. Sixth one is this undertaking accepted at board. Sixth one, there is no penalty, sir. Seventh one, breach of any other provisions of this act or the rules made thereunder. It is 50 crore, sir. That's it. If any questions with respect to examination point
Right.
of view, they can ask me, sir. I am available for you.
Yes.
For 5
So
more
these-
minutes, I will continue.
Yes. So these are the two things which are most important. One
Yes,
is
sir.
this
Yes, sir.
chart and another is
Hmm.
the definition part.
Yes, sir.
And
Yes, sir. Nothing
definitions
else.
they can ask in reverse way also. So
Yeah,
they may give you
reverse.
example and
Ah.
they may like you to identify okay, which type of this description fits which definition. Right? So they can ask it either way. And
Yes.
now we'll go on to the case study. Till that time, if you have any questions, you can ask. Or otherwise, we'll be doing a case study on this DPDP Act also, because it will help you in having a clarity on the concept of this professional ethics also. Because this is the age of AI, and in AI, you are sharing various informations with AI also, like various platforms are being used. So whether an insolvency professional can make use of those platforms, to what extent they can share the information. So this we'll be studying now. Before that, if you have any questions, you can ask. I hope this is visible now. Is it visible? My screen is visible?
Visible, sir.
Okay. So, Sudhakarji, please take up this case study also.
Yes, sir. So, a statutory auditor is a data fiduciary in exactly the same sense as the insolvency professional or the advocate.
I hope it is visible clearly to all the participants.
Yes, sir.
Yes, sir.
बड़ा भी
Yes,
कर
sir.
दिया, sir.
Yes.
Yes, sir. Then the client's employees, related parties, and financials are personal data whose purpose and means of processing the CA firm decides. But the CA carries a second independent layer of exposure that neither of those two professions carries in quite the same form. The Chartered Accountants Act 1949 and the ICAI Code of Ethics. A single careless prompt into a free AI chatbot can therefore trigger a DPDP penalty, an Information Technology Act offense, and a professional misconduct finding, all from one act. This case study works through that interplay using a realistic fact pattern.
Here, they have taken the example of a CA firm, but the same is applicable for insolvency professionals also.
Yes, sir. So here the case. The firm is Shanta Verma and Associate Chartered Accountants. Engagement, statutory audit of a mid-sized manufacturing company, plus the ITR filing of its promoter directors. The personnel are CA Neha, a newly qualified engagement team member working under partner level review. And the trigger is a heavy year-end deadline pressure, a free public AI chatbot used to save time on drafting and summarizing. Here, during the final week of a statutory audit, CA Neha is behind on the related party transactions, hereinafter known as RPT, note, and the management representation summary. To save time, she uploads 3 items to a free publicly available AI chatbot on her personal laptop. A trial balance and general ledger extract, including related party balances and pricing. The RPT working paper naming the promoter directors, their PAN, and the terms of transactions with entities they control, and the draft computation of total income for 2 promoter directors prepared for their personal ITRs, including salary, capital gains, and bank interest figures. The chatbot returns a clean, well-drafted related party transaction note and a tidy income computation in minutes. Neha pays both into the working papers and moves on. She does not read the platform's terms of service, which, like most free consumer AI tools, permit the platform to retain prompts and use them to improve its models. 3 weeks later, during the engagement partner's final review, a reviewer notices the RPT note reads unusually smoothly and asks how it was drafted. Neha explains what she did. The partner now has a completed audit file that may contain a live confidentiality breach and has to decide what to do about it before the audit report is signed. Point number 2, issues for determination. Has CA Neha, through her firm, made an unauthorized disclosure of personal data within the meaning of the DPDP Act 2023? And if so, what is the firm's exposure under the schedule to Section 33? Does the same act separately expose the firm under Section 43A and Section 72A of the Information Technology Act 2000? Does uploading client working papers to a public AI tool amount to professional misconduct under the Chartered Accountants Act 1949, independent of the two statutes above? What must the engagement partner now do, both to remediate the specific file and to prevent recurrence across the firm? These are the 4 points. Then, where the firm stands. Data fiduciary. By deciding what client information to process and how, for the audit and ITR engagements, the firm is the data fiduciary for both the promoter director's personal data and the related party transactions, counterparties data, Section 2 definitions. The AI platform which received and processed that data is a data processor. Consent and purpose limitations, Sections 5, 6. The engagement letter and the ITR authorization gave the firm consent to use the data for the audit and the return, not to route it through a third-party commercial AI platform whose own terms permit retention and model training. That purpose was never disclosed to or consented to by the promoter directors. Then, no valid processor contract, Section 8.2. A generic I agree click on a free consumer chatbot's terms does not amount to the valid contract the Act requires before a data processor may be engaged, particularly one that reserves the right to train on user input. Breach of security safeguards duty, Section 8.5. Sending identifiable PAN, income, and related party transaction data to an open third-party server with no encryption commitment and no data isolation guarantee is the opposite of a reasonable security safeguard the data fiduciary is bound to maintain. This is the specific obligation that carries the heaviest entry in the schedule to Section 33. The schedule to Section 33 sets out the penalty framework the Data Protection Board would apply to a proven breach. It is reproduced below because the first entry is the one most directly engaged on these facts. Serial number 1, subject matter of breach, which we had just now spoken. Sir has explained and Mr. Kumar also has explained. Breach in observing the obligation of data fiduciary to take reasonable security safeguards to prevent personal data breach under subsection 5 of Section 8 may extend to 250 crore rupees. The second one is breach in observing the obligation to give the board or affected data principals notice of a personal data breach under Section 6 of Section 8 may extend to 200 crore rupees. Breach in observance of additional obligations in relation to children under Section 9 may extend to 200 crore rupees. Breach in observance of additional obligations of significant data fiduciary under Section 10 may extend to 150 crore rupees. Breach in observance of the duties under Section 15 may extend to 10,000 rupees. Breach of any term of voluntary undertaking accepted by the board under Section 32, up to the extent applicable for the breach in respect of which the proceedings under Section 28 were instituted, breach of any other provisions of this act or rules made thereunder may extend to 50 crore rupees. Sir, here it says may extend to, which means that minimum is that amount, sir.
This
Or
is the
minimum
maximum
can be-
amount. Depending upon the severity of the offense, they may decide actually.
But it can be less than 50 crore also, sir?
Yes. This is the
Ah.
maximum.
Right. So, on these facts, the firm's exposure sits squarely under item 1 of the schedule, breach of the section 8(5) security safeguards obligation, which carries a penalty that may extend to rupees 250 crore, the highest entry in the table. No breach notice to the board or to the data principals has yet been triggered under item 2, since the data has not been shown to have leaked further. But if the platform's retention later surfaces the data elsewhere, item 2 becomes live as well.
So I think
Yes,
we
sir.
have got the gist of this
Yes, sir.
case study.
Yes, sir.
Now, what we will do, we will devise a similar, this was for Chartered Accountants Act, but we will devise a similar case study for insolvency professional. And we can take the example of a CIRP. CIRP has commenced, claims have come, and now those claims, that personal information of the various claimants is being shared with a third party, making use of AI for processing of those claims. So in that situation, what is the under which definition the RP comes, whether is a data fiduciary, data principal. They can say you identify the person who has filed the claim. So in under what definition it fits in, whether it's a data fiduciary, data principal, or data processor, and things like that. Basic idea is that we should understand the concept, and we should be able to identify the parties involved. So this was for today, and we'll be having a regular batch from 17th of August. I've shared a lot of material in the group, so you please go through that material. Please attempt online tests. Even if you even if you are not very sure about your preparedness level, but I will request all of you to please attempt those online tests. It won't take much time. It may take 5 to 6 hours maximum, and tomorrow you can devote that much time. So it will help me in modulating my deliberations accordingly, that what are the areas, which are the areas where the students are lacking, because the purpose of all of us is the same, to clear the examination.
Yes, sir.
Okay. Thank you so much.
Sir, 1
Yes,
minute, sir.
please. Yes,
Sir,
please.
I have a small doubt, sir.
Yes,
Sir,
yes.
the harmonizing of RTI and DPDP Act, can you please explain that, sir?
Yes, actually, earlier there was Right to Information Act. So, Right to Information Act prohibited disclosure of personal information. But now this act has come, and by virtue of the rules of interpretation, a later act always takes care of the earlier act. So, the Right to Information Act, it prohibited disclosure of personal information. So, suppose somebody filed an RTI application, so they said that okay, this personal information cannot be revealed. But
Yes.
now here the parameters are different, and they may disclose, they may reveal the personal information also. So this act supersedes the Right to Information Act.
Right, sir.
And the section also 81J or something, which was being shown.
Yes, sir. 81J. Yes, sir.
Yes. So that has been superseded now by virtue of this DPDP Act.
Right, sir.
So just 2-3 things to remember. Number one, definitions. We must remember the definitions by heart. And if somebody asks us, so they may not ask you direct questions. What they may ask you, you are an insolvency professional and you are processing the claims. Now identify the parties. An operational criteria. An operational criteria fits into the definition of, and they may give you 4 options: data processor, data fiduciary, data principal, and things like that. So you should be able to identify.
Right,
Right?
sir.
So definitions both ways, direct as well as indirect, and then penalty chart, and then
Right, sir.
appeal provisions. So this is the minimum. I have already shared the penalty chart also in the group. So at least So suppose they ask you, they will not ask you much. They may ask you only 1 or 2 questions, but you should be able to answer them. That is the
Right, sir.
idea.
Right, sir.
So I hope you enjoyed this session, and I'll share the recording also in the group.
Right, sir.
And
Thank you,
tomorrow
sir.
you can take advantage of the time available with you, and you please try to
Right,
attempt all the online tests.
right, sir.
Right? So your score is not important, but your understanding is important, and let me also understand your level of preparedness, because that is the ultimate objective. Right?
Right, sir. Right, sir.
Thank you. Thank you so much.
Thank you. Thank you, sir. Good night, sir. Good
If
night,
you have
everyone.
any questions, you can ask.
Right, sir. Thank you, sir.
Otherwise,
Good
we'll
night.
be meeting on 17th at 8:30. Right?
Right, sir. Right, sir.
Right, sir.
Okay. Okay.
Thank you, sir.
Thank you. Thank you.